I've learned something about podcasting. It's hard and it's unpredictable. Things happen that you don't expect. Files corrupt, a person gets sick, or your recording space is taken over by crickets. If I ever do another long-form show, or another season of this show, I'll definitely make sure a majority of the episodes are finished before putting any of them out. I've noticed a parallel, not life-altering like someone being in prison, but an ironic situation. It seems like when my schedule gets on track, when things seem to be going the way they should, something happens. There's a twist and a setback. It reminds me of Richard Nicolas's journey through the legal system, a journey that was full of twists and setbacks, some of which we're going to talk about today. I'm Brooke, and this is episode 9 of Convicted. In the previous episode, we met Jeff Garanther, who works at the firm Venable, and he was assigned Richard's case by Judge Bennett. Prior to that time, the case had been appointed to Rachel Kamins by a judge named Andre Davis. The quote of the judge saying that he believed this case could be one of actual innocence came from Judge Davis. Rachel wrote the initial habeas petition, and she was also the person who made contact with Dr. Shute about his testimony. She was the one who basically got his recantation, verbally and in a letter. After Dr. Shute said that his testimony was misinterpreted, to quote Rachel, the case got real. The case was passed to Judge Bennett because Judge Davis changed positions, and at that point, the case was also transferred to Jeff at Venable. Remember, Richard wasn't entitled to counsel, but something about this case inspired 2 separate judges to appoint him counsel anyway. The habeas continued, then it stopped, then it started again, and that's where we left off. The last episode was very legal heavy. This one is too. If you have questions, be sure to email them to me for the next panel. The guest host will be Rebecca Lavoie, and the panelists will be Rachel Kamins, Colin Miller, and Donald Jason, an expert in the area of autopsy and forensic pathology. We'll talk about Richard's habeas right after the break. Movement Watches is a company that was started by 2 broke college kids. They wanted stylish watches, but they couldn't afford them. How many of us can understand that feeling? So to solve their problem, they started their own watch company so that they, and we, can have stylish watches that don't break the bank. It kind of reminds me of my own journey into podcasting. I didn't know about wrongful conviction, but once I found out, I wanted to make sure that everyone knew. I wanted to help solve a problem, just like Movement. Watches styled like the ones you see in department stores can cost you more than your rent, but they start at just $95 with Movement, because they figured out that selling online lowers the prices because there's no middleman. I love the classic design and the amazing quality, and I'm not alone, because they've sold over 1 million watches internationally. You can get 15% off today with free shipping and free returns by going to movement.com/convicted. Movement is spelled MVMT, so it's mvmt.com/convicted. This watch has a really clean design. Seriously, I've been getting compliments ever since I put it on. Now is the time to step up your watch game. Go to mvmt.com/convicted. Join the movement. I'm going to give you a short refresher of the starts and the stops and the starts and the stops that led up to today's episode. Remember, Rachel had written the initial habeas petition, but in 2012, Jeff Garanther and Venable were heard in the court of Judge Richard Bennett on the issues that petition raised. Those issues included ineffective assistance of counsel regarding lividity, the fact that GSR evidence presented was unreliable, and it was irrelevant and prejudicial to share with the jury the fact that Richard was a gun owner. The first pause in Richard's habeas came because the GSR evidence had not been exhausted by a lower court. In order for a higher court to rule on an issue, a lower court first has to hear it and make a ruling. So they took it back to the circuit court, and a ruling was made against Richard. The second start of the habeas began with a motion for discovery, because the defense believed there was evidence that could help Richard that had not been shared during the trial, or ever. Judge Bennett ordered an in-camera review of the files, and it was discovered that there were 2 witnesses that could have potentially heard a gunshot at the time that would have corroborated Richard's timeline of events on the night Asia was murdered. Once again, though, the proceedings had to pause because the usefulness of these 2 witnesses had not been heard in the lower court.
It was a big issue, and one we were hoping to avoid by saying, yeah, the state already looked at this and didn't consider it fairly. Judge Bennett, you really ought to handle this. But he, perhaps rightly, said, no, wait a second, some of this is new. Let's give them a chance to get it right. And I think that's what we then did, went back to the state court. They didn't get it right, and that's when we came back to Judge Bennett.
A second time, the case went back to the lower court so they could rule on this new information. And for a second time, the lower court ruled against Mr. Nicolas. The circuit court made the statement that even though the witnesses had not been disclosed to the defense during Richard's trial, they wouldn't have been useful anyway. I think that's probably false, but I'm not a judge, and my opinion on this matter isn't important to the legal system. Because of this ruling, Mr. Garanther and Richard were able to take his case back to federal court for a third time to complete the habeas petition with Judge Bennett. His original habeas was filed in June of 2012, but it wasn't until November of 2014, after several trips back and forth from the circuit court to the federal court, that arguments were finally fully able to be heard and ruled upon.
I was there for the habeas corpus, Judge Bennett, and he was. Have you ever seen that movie Hurricane? At his habeas corpus, remember how the federal judge was animated and like pumping his fist up in the air and hooping and hollering? Remember that? It's but Judge Bennett was the exact same way. He was pumping his fist up in the air and said that he was going to do the right thing, and it was a show, man. He was impressive.
The arguments made in the final version of the habeas to Judge Bennett by Richard and team were a Brady violation, ineffective assistance of counsel based on lividity, GSR, and the dual inference jury instruction. So let's break those down into their individual arguments, starting with Brady. Jeff argued that the statements of Benson and McKenzie, the 2 witnesses who were not disclosed to the defense, were, quote, more than sufficient on their face to constitute favorable impeachment evidence, especially in light of the prosecutor's post-trial letters opining that the time of death was their whole case. I mean, they heard a loud bang at the time Richard said that a gun was shot. The prosecution said that shot happened 2 hours earlier. These witnesses definitely favored the defense. It wasn't just about the noise, though. I mean, the fact that they had possibly heard a shot is important. But they'd also seen a suspicious-looking car. And really, just the fact that they were there. They were so close to where Asia's body was found. Maybe they noticed something and didn't even realize it was important. The problem is, we don't know. And the defense didn't know because no one told them. No one told Richard Nicolas's team that there were 2 people just feet away from where his baby girl was murdered. No one told them that those people heard a sound that could have been a gun fired at a little girl. Those 2 reasons alone make me feel a reasonable degree of doubt. I can't understand how those same feelings of doubt weren't shared by the prosecutors. I can't think of any ethical reason that they wouldn't have shared that information with the defense. According to the American Bar Association, quote, the duty of the prosecutor is to seek justice, not merely to convict. But when a prosecutor doesn't share vital information, are they seeking justice, or are they just trying to win?
And I think these prosecutors, to the extent they knew about it, we don't even know for certain that they knew. It could be something that the detectives hid from them, at least did for a while. But it's something that, to the extent they made a strategic decision, it was, we're not going to let this get close. We've looked at this. We don't think it's relevant. But you had two people who heard something like a gunshot at the exact same time Richard said there was a gunshot. And Richard would have had no way of knowing about these two witnesses independently. So his lawyers then, Christina and Howard, his lawyers on appeal, me, any one of us would have loved to have had that evidence in front of a jury as a way of creating reasonable doubt. And I think our chances of creating reasonable doubt would have just been so much greater than their chances were without the information.
Not to run this point into the ground, but a Brady violation, according to the United States Supreme Court, requires prosecutors to disclose exculpatory evidence in the government's possession to the defense. The type of evidence that's required to be disclosed includes any evidence that might be favorable to the accused, anything that helps negating a defendant's guilt, something that might cause a defendant's potential sentence to be reduced, or even going to the credibility of a witness. I know the facts of this case, and this is pretty clearly a Brady violation. The argument of ineffective assistance of counsel was twofold, including the dual inference instruction and lividity. If you remember back, the dual inference instruction was an instruction given to the jury that significantly lowered the state's burden of proof. In the words of Jeff Garanther, it eroded the presumption of innocence. The state repeatedly relied on evidence, while not flattering to Mr. Nicolas, also was not proof that he was a killer. He didn't have a car seat. He bought a life insurance policy on his daughter. He was inconsistent with child support. He owned guns. But not one of those things, or even all of those things combined, make him a murderer. And not one of those things support the state's timeline of events. However, the dual inference clause said that didn't matter. It was okay to use bad choices that Richard had made as evidence. He didn't have the presumption of innocence. What he had, because of this instruction, was a history of making parental mistakes. Mistakes that the jury could use to convict him of murder, even though there was no direct connection. Lividity. We've talked about this a lot, and in this particular argument, lividity is a factor in proving that Richard Nicolas's defense counsel were ineffective.
He'd received what's referred to as ineffective assistance of counsel, that his lawyers at trial were not fully prepared to do certain things. For example, the one you mentioned, I think, was to cross-examine Dr. Shute, the expert on lividity, who was very key in the trial, and you've probably seen the letters from the prosecutors to him, telling him how it was the key thing. And you may have seen the letter back from him many years later saying, hey, wait a second, that shouldn't have been the key thing. This is part art, it's not entirely science, and it's not an exact science. So when I said it was 2 hours earlier, I was really giving a range. I hope you didn't base your entire prosecution on my testimony alone, which we thought was important for showing the materiality, which is an important issue up on appeal in front of the Fourth Circuit, the materiality of the Brady evidence, because it specifically refuted the timing, or at least was something the jury should have considered about the timing of the gunshot.
The testimony that lividity could have fully fixed on Asia's side in 2 hours was wrong. That's not my opinion or bias. It's a fact, a medically substantiated fact. Lividity sets at around 8 hours. So if there was fixed lividity on Asia's side, her body had to have been positioned that way after she was removed from the scene. An important thing to remember is that lividity wasn't looked at while Asia's body was still at the scene. It was recorded 13 hours later at the morgue. 13 hours is well after the 8 hours that it takes for lividity to become fixed. There's no documentation of what happened to Asia's body during those 13 hours. In Dr. Schute's own letter, he stated that it was possible that while inside the body bag, Asia could have been shifted to her left side and then laid flat once again when she reached the morgue. Richard picked Asia up around 6:30 p.m. He took a picture with her in a photo booth at either 7:03 or at 7:43 p.m. We know that because those were the only 2 times that specific type of picture was taken. Asia was pronounced dead a little after 10 p.m. Regardless of whose accounts of events you believe from that evening, from the time she was picked up to the time she was pronounced dead, there was not enough time for lividity to fix. We don't know how the lividity pattern formed. There's no concrete evidence to tell us. But what we do know is that it was impossible that lividity was fixed at 10 p.m. because there was simply not enough time for that phenomena to occur. Her body was warm, and she was bleeding. These were recorded as fact by the personnel on site. Those observations are the opposite of the characteristics of a body that has fixed lividity. I'm not very good at math, and prior to this podcast, I didn't even know what lividity meant. After a little research, though, I'm able to identify that the state's timeline isn't biologically possible. It seems to me that a dream team of the best attorneys should have also been able to come to that conclusion. They could have found someone who was good at math and specialized in lividity and had them explain it to the jury. At the very least, they could have simply asked the question to Dr. Shute: was there enough time for lividity to fix? Or is lividity on its own an accurate indicator of time of death? Spoiler alert, it's not. Christina Gutierrez was out of town at the time, and so it was up to Arthur and Howard to handle the situation. Howard himself told us that they didn't realize what a huge role lividity was going to play in the case. They investigated by calling Howard's son, a pediatric resident at a local hospital. He told them that it wasn't that big of a deal. The thing is, he was more or less right, because lividity isn't an accurate determinant of time of death. What makes this feel like ineffective assistance of counsel to me is that they never asked the questions. They never refuted Dr. Schute's 2-hour estimate, and they never asked about lividity as an effective indicator as the sole item considered in determining the time of death. You know who was effective in the area of lividity? By effective, I mean able to sell it, not to be confused with someone seeking justice. The prosecution. They knew the importance that lividity could play in this case. They even said so in their thank you letter to Dr. Shute. Quote, "We are 100% certain that your testimony was the reason this jury had no difficulty reaching this verdict."
It's a really interesting point because I think on the state level, the argument we either had made or would eventually make about those letters that were found last, the one we got from Dr. Shute, the ones sent to prosecutors, we never argued that those should have been disclosed before trial. Obviously, they didn't exist before trial. So it's not that those letters were Brady, but the letters really amplified the Brady violation because it showed the extent to which the prosecution was trying to fit the events into their very narrow theory of the case. They had this lividity expert who was going to say it happened at a certain time. And as soon as Richard said, no, wait a second, it didn't happen then. The shooting happened around 9:45. They weren't trying to figure out, could he be right? They were immediately focused on refuting that. So they looked at everything that might have supported that theory with a jaundiced eye. And you could see how enthusiastic, passionate really they were about that in their letters to the witnesses at trial.
That makes me sick. It makes me horrified. One question about lividity and fixation time, or lividity as a tool for determining time of death, could have made all the difference. Dr. Shute himself said in his letter, "It is my opinion, based on my training and experience, that lividity should not be solely relied upon to make determination of time of death, because it's unreliable for this." One question, and one answer, might have changed everything. And one more thing. Why didn't anyone, except the multitude of convicted listeners, ask about the substance consistent with popcorn in Asia's stomach? Does not asking about that at trial seem ineffective to you? Last week, I was at a conference called Podcast Movement. It's a big gathering of podcasters. What I didn't realize was that some of the sponsors were going to be there too. I was actually able to meet the people from Stamps.com, and they were so nice. I use Stamps.com pretty much every day for packages, letters, and sending out swag with my logo stickers on them. So it was really great to meet the people who helped to save me so much time, and know that they're good people also. Last week, I had to go to the post office to check my P.O. box, and while I was there, I decided to drop off a couple of packages that I had printed postage for right at my desk using Stamps.com. The postal worker lady was very nice, but when she saw the Stamps.com logo on my packages, she got curious. She asked me about my digital scale, she asked me about the convenience of printing at home, and now, even my local post office worker is considering using Stamps.com service. I use Stamps.com because it saves me time and money, and the people that I met from Stamps.com were super friendly and helpful. That's a big sell for me. And right now, you too can enjoy Stamps.com service with a special offer that includes a 4-week trial, plus postage and a digital scale without long-term commitments. Go to Stamps.com, click on the microphone at the top of the homepage, and type in Convicted. That's Stamps.com, enter Convicted. Stamps.com. Never go to the post office again. Well, unless you work there. The final argument made in the habeas petition was an additional argument of ineffective assistance of counsel. It was related to gunshot residue. I think Jeff explains it best in the petition when he says, allowing admission of the GSR evidence was a denial of the fundamental fairness. Basically, false science was introduced, and the introduction of that science equals the lack of a fair trial. Remember back to my conversation with the forensic scientist? In order for a substance to be determined as gunshot residue, it has to have all 3 of the particles that make up GSR. The particles on Richard's hand were only tested for 2 of the 3 particles. So there's no evidence that those 10 particles were in fact gunshot residue at all. They could have come from a number of sources, including the copy machines that he was working with that very day. I've seen 2 police forms relating to the GSR evidence. The first one is a 1-page form requesting that a sample needs to be tested for GSR. The form is labeled Request for Examination Form 89/236. That form has Richard's name and case number, and also the name of the officer who recovered the evidence written in. The officer was Detective Daryl Massey. The bottom half of the form is blank with the instructions: describe evidence items and types of examinations. List property numbers and specify exact sources of individual evidence items below. That translates to me as be as specific as possible about the evidence. Scrawled in that large empty space are the words GSR examination result and then the evidence number. I can only assume it was written by Detective Massey because his name was signed on the form. Maybe his hand hurt and he couldn't bring himself to write more details. But even with his limited amount of information, he did receive a response. The response form is labeled Gunshot Primer Residue Report, and there's a 92 and a slash. It's addressed to Detective Massey, and it states, fill in the blank style, that Richard Nicolas had been tested for GSR at 11:30 p.m. on July 26, 1996. It goes on to say the samples had come from the backs of his thumbs and forefingers. Then, circle style, the words were not were circled in the statement pre-typed about gunshot residue from his right hand. The word were was circled in the pre-typed statement about GSR being found on the sample from his left hand. Then, in a box taking up about the bottom third of the page, was the word conclusion. There were 2 check boxes, and the person filling out the form is required to choose one. The box that was checked on this form stated that gunshot primer residue was found on the hand of the subject. There's a possibility that this residue was transferred from the surface of a firearm or from an object which lay immediately adjacent to a firearm during its discharge. Most probably, however, the subject's hands were immediately adjacent to a discharging firearm or were themselves used to fire the firearm within a few hours of 11:30 p.m. on July 26, 1996. The time and date were written in fill-in-the-blank style. The other checkbox states that no GSR was found on the person being tested. It seems to me that there should have been a write-in section or a third box. According to the guidelines of the Scientific Working Group on Gunshot Residue, the agency that sets the standards in the field of GSR, the strongest statement that could have been made about those 2-part particles is that the particles found were consistent with GSR, but also a number of other environmental factors. The checkbox was wrong. They had not performed a definitive test on the particles to determine if it even was GSR at all. The document was signed by Daniel Van Gelder. Mr. Van Gelder had some credibility issues in the area of misrepresenting evidence. It's off track for this episode, but if you're interested and want to look into it more, I suggest entering Daniel Van Gelder, GSR, and Baltimore into a search engine. Is it wrong that I wasn't surprised by the results? If, in a totally hypothetical situation, we were to stipulate that it was GSR on Richard's hand, those 10 particles were meaningless because it had been discovered that in that particular police station where Richard was taken, GSR was everywhere. The fact that it was connected to a firing range made the possibility of GSR transferring onto Richard's hand from touching basically any person or any object a likely reality, especially since there was such a small amount of particles and they were on his non-dominant hand. It scares me to think that
if you or I were taken into a police station now, there's especially one that has a firing range, there's so much gunshot residue around that we would have trace amounts. And in fact, I think it was the case that Richard had been taken to one of these police barracks that had a firing range, but for whatever reason, the amount of gunshot residue they took from his hands might have been those sort of trace amounts. It should not have been admitted at trial. And the City State's Attorney's Office had, at some point after the prosecution, stopped using this evidence for that very reason. So I felt like that was our second strongest argument.
So that was it. Those were the arguments that were made in Richard's habeas hearing. 1 Brady violation, due to the witnesses not being revealed. 3 issues of ineffective assistance of counsel, the dual inference jury instruction, lividity, and the misrepresented GSR evidence. All of these arguments are valid, and most of them seem like deliberate, unethical acts to me. So when I was reading the judge's response for the first time, I felt a sense of suspense that I couldn't shake. I don't have a legal brain. I have a social worker brain. I want to give people the benefit of the doubt. But having read all of the other documents in this trial, I realized, despite intention, that's just not how the legal system works. A little over a year ago, when I started podcasting, I never thought it would turn into a business. And I especially did not expect to need to hire people to help me with the process. Hiring the right person is so important. I'm glad that I have ZipRecruiter to help me. With ZipRecruiter, you can post your job to 100+ job sites with just one click. Then, their powerful technology efficiently matches the right people to your job better than anyone else. That's why ZipRecruiter is different. Unlike other job sites, ZipRecruiter doesn't depend on candidates finding you. It finds them. In fact, 80% of employers who post a job on ZipRecruiter get a quality candidate through the site within 1 day. No juggling emails or calls to your office. Simply screen, rate, and manage candidates all in one place with ZipRecruiter's easy-to-use dashboard. Find out today why ZipRecruiter has been used by businesses of all sizes to find the most qualified job candidates with immediate results. And right now, my listeners can post jobs on ZipRecruiter for free. That's right, free. Just go to ZipRecruiter.com/convicted. That's ZipRecruiter.com/convicted. One more time. To try it for free, go to ZipRecruiter.com/convicted. On March 30th, 2015, Judge Bennett filed his response. And as required, he addressed each argument, giving his reasons for granting or denying that specific part of the habeas. The first issue he addressed were arguments that Richard's counsel had been ineffective. He started with lividity. His opinion on the matter touched on several items, but the ones that stood out to me had to do with not calling a rebuttal expert and consultation with an expert to prepare for cross-examination. In Judge Bennett's ruling, he said that not having a, quote, battle of experts is sometimes a strategic move on the part of the defense, and it very well could have been in this case. As far as appropriate preparation for cross-examination, knowing to ask the right questions, Judge Bennett said that because one of the defense counsel had consulted with a forensic pathologist before the trial, that they had indeed prepared for this witness. I've been researching this case for a long time. I've talked to many of the players, including Howard Cardin. At no time did I find any evidence that anyone was consulted other than Dr. Cardin, Howard's son, who is a pediatric doctor, not a forensic pathologist. I asked Rachel once, since her practice is in matters that happen post-trial, is it the job of the original attorney to fall on their sword? Should an attorney who defended a client admit that they made a mistake and confess now with hindsight they see the error of their choice? Near the end of my interview with Jeff, he made this statement.
And this whole issue's always been a little troubling to me because it's always tough when you're talking about whether effective assistance was provided. So, for example, if the way for him to get a fair trial now is to say, I should have argued those other 3 issues on appeal, and some finder agrees that that should have happened, I'd be perfectly comfortable with that.
I think that's noble, but Rachel told me that it's not common. I guess that makes sense. People don't always like to admit their mistakes, even if the rest of someone's life is on the line. On the dual inference argument as part of the ineffective assistance of counsel claim, Judge Bennett said this, quote, because the court properly instructed the jury on the matters of the beyond a reasonable doubt burden of proof and the presumption of innocence, there was no reasonable probability that the jury was misled or that the result of the trial would have been different if not for counsel's alleged error. Relief under both arguments under this umbrella of ineffective assistance of counsel were denied. Judge Bennett's response to the ineffective assistance claim on the matter of gunshot residue was brief. 3 sentences. The middle sentence is the one that I'm going to quote to you. The petitioner has not identified any clearly established federal right or provision of federal law in connection to this claim, nor has this court's investigation revealed any such right or provision warranting the requested relief. I asked Rachel to help me understand what exactly that meant, and she told me that basically Judge Bennett was saying that the attorney had not cited a federal law that had been violated, and the judge himself also couldn't find one. It sounds to me like the judge was saying his hands were tied. He didn't have any power in this situation. So, this claim was also denied. 3 of Richard's 4 arguments were denied. The one that remained was the Brady evidence, the witnesses that had not been revealed to the defense. The explanation of this decision was much longer than 3 sentences. It stretched from page 22 to 33 in the document. It's obvious that Judge Bennett takes Brady very seriously. In Judge Bennett's long written deliberation determining if he should grant relief on the grounds of Brady, he makes this statement. The Brady requirement extends beyond just the prosecutor. The knowledge of some who are part of the investigative team is imputed to the prosecutors, regardless of the prosecutor's actual awareness. I don't think I really realized this. I mean, when I picture a Brady violation, I see a prosecutor not telling the defense a fact because it would hurt their case. And though that is a Brady violation, it's not the threat. Everyone who's part of the investigative team, the team that should be seeking justice, is part of Brady. Any critical information discovered by anyone, including a detective or a police officer or a medical examiner, has to be shared. Even if one of the members of the justice team doesn't share the damning information with the prosecutor is still at fault. They're still committing a Brady violation. Because in the world of courts and Brady, the buck stops with the prosecuting attorney. Judge Bennett says that in order for this Brady claim to prevail, it has to be established that the withheld evidence was not only favorable to the defense, but also not having the evidence likely influenced the result of the trial. Would the information have changed the mind of juror number 72? I don't know, but that's the point. He wasn't given the opportunity to hear the evidence. But the fact that it could have influenced him, or any of the jurors, is what makes this withholding of evidence a Brady violation. So, did these two witnesses, or the lack of these two witnesses, meet the requirements according to Judge Bennett? As for the favorability to the defense, Judge Bennett said that the linchpin for the state's premeditated murder theory was the time of death, the theory that Asia was shot in the parking lot of the movie house. The witnesses heard the sound around 9:45. Around the time Richard claimed a gun was being fired. Obviously, the witness testimony aligned with Richard's version over the version given by the state. Judge Bennett agreed, and on this first issue that needed to be satisfied for relief under Brady, he said that Richard had indeed satisfied this burden. As for the second requirement, proving that not having this evidence available was likely to have affected the result of the trial, this is what Judge Bennett had to say. Quote, "It is clear that no fair-minded jurist could have concluded that the suppressed statements were not material. In particular, Mr. Nicolas offered his own evidence that undermined the evidence used by the prosecution." In other words, this requirement was also satisfied, meaning that relief was granted on the Brady issue. This was, very clearly, a Brady violation. 3 arguments for relief were denied, and 1 was granted. So what are the next steps? Judge Bennett's decision ended with 1 paragraph labeled Conclusion. For the foregoing reasons, petitioner Richard A. Nicolas's petition for writ of habeas corpus is granted in part and denied in part. Specifically, the petition is granted with respect to the petitioner's Brady claim and denied with respect to all other claims. Listen really closely to this next sentence. It gives me chills, and sometimes tears. Accordingly, petitioner's conviction and sentence are vacated, and the case is remanded to the Circuit Court of Baltimore City for a new trial. He did it. After all those years, all that court hopping, all those hours in a cell, Richard had been granted a new trial. There's another sentence in the conclusion, though. However, this court's judgment will be stayed for 30 days to allow for an appeal. Absent an appeal, a decision will be made by the Circuit Court for Baltimore City concerning the petitioner's continued confinement. The state could appeal or not, and if they didn't, Richard would be given back his presumption of innocence, and he might even go home.
I think that what he did was he saw what the implications were just by looking at the tip of the iceberg. And Judge Bennett fully realized that we were going to expand on this information, and that if I did get back down to Baltimore City, that I was going to go home. So it's I think he saw it.
I can't imagine what that day was like for Richard, for his family, and for everyone who had been involved in the case.
Like, finally somebody was paying attention. In my mind, I don't care what people told me, he was coming home the next day. So, I could not believe that we were on such a high. For the first time in 20 years, I could actually see him sitting at that empty place at my dining room table on the holidays.
I had to wonder, though, having read through the labyrinth Richard traveled through to get to this point, and not to sound pessimistic, but what about those 3 losing arguments? They didn't sound like losers to me. So I wondered if this is a legal pick your battles kind of situation, or could those issues also have been appealed?
Completely are thinking about it, but I think it was, again, that the Brady argument was so strong. It's not as if you don't want to take the time on that or anything else, but you have to separate the wheat from the chaff, and if you go in with too many arguments, it's going to seem too diffuse and it lessens your chances. And some of those were weaker than others. And I'm not sure they weren't all losers. At the time they were dropped by Judge Bennett. And I don't think we pushed them that hard, again, because the Brady issue seemed to be the one that was going to get us there. And in my limited experience with these, the more issues you outline, the more likely you are to go down, because the court will find different ways to say, look, that just didn't, that's not the reason you lost below. Whereas if you come in with one really strong issue focused on that, you're going to get their attention. And I still think that was the right strategy, because there's no doubt we had their attention in the Fourth Circuit. They knew the record.
The state did appeal. Apparently, 3 out of 4 wasn't good enough for them. They appealed to the Fourth Circuit, which is a panel of 3 judges.
It was a good day. I'm trying to think whether it was the best day, whether it was the apex of things. It may well have been, because we left the courtroom feeling very strongly that Judge Bennett was going to reverse the state court. We knew that if that happened, the state, of course, was going to appeal that up to the Fourth Circuit. That didn't mean we were going to get a new trial in the state, but Judge Bennett's a strong judge. The Fourth Circuit is much less conservative, much more progressive than it used to be. I know from the moment we listened to Judge Bennett in that hearing and left the courtroom up until the time, probably a year or more later, when we went to argue the case in the Fourth Circuit, I thought there was a very good chance we would be trying this case in Baltimore City again. And that's something that Matt and Richard and I were talking about all during that period.
We'll hear from the judges at the Fourth Circuit and the results of that hearing next time on Convicted. Episode 10 will be out really soon. It'll be followed by the panel episode I mentioned at the beginning of this episode, which will drop around September 9th. If you have questions, be sure to email them to convictedpod@gmail.com as soon as possible. The last episode of Convicted will be released on September 11th. You can see pictures, donate to Richard's Defense Fund, download the transcripts, and view other documents at convictedpod.com. The music was created by Blake Maples, and you can see and hear his work at blakemaples.com. We'll be back soon. I'm Brooke. Thank you so much for listening.